Hi all, happy Monday. Welcome to the Wife of Caesar. My name is Michelevian or Michelevian, either is fine. As you know, the Wife of Caesar is Streiner's project to talk about anti-corruption or corruption using everyday words so that we can fight corruption in our day-to-day lives with a little bit more than just good intentions. Okay, so every episode of the Wife of Caesar has a piece of news, a case, and a typology. Today they are all rolled up into one, and it is because we are going to talk about Walmart, of course. Of course. All right. Well, first of all, what's going on? This week, last Thursday to be precise, Walmart finalized their inquiry and their case with the DOJ and the SEC. They settled their corruption probe. It's an investigation that's lasted for 7 years. And Walmart was charged with several acts of corruption. And finally, I mean, everyone who is at least in this medium has kept close track of the Walmart situation. We expected something entirely different, and in any event, the case was settled this week. Okay, so let's discuss a few basic concepts, a few notions. First of all, the Foreign Corrupt Practices Act. What is that? That is the law, the U.S. law that forbids going abroad and paying bribes, going to a different country and paying a bribe to a government official in that country. Now, that law, as we have discussed at great lengths, covers 3 crimes. Essentially, the crime of paying a bribe, the crime of failing to have a compliance program that prevents corruption, and the crime of falsifying books and records, cooking the books in order to hide corruption. Okay, now this law, this particular statute, the FCPA, is enforced by 2 different government authorities. On the criminal side, on the criminal aspect of the law, it is enforced by the Department of Justice, and they essentially perform prosecution functions in the U.S. On the administrative or civil side of things, the Securities and Exchange Commission, or SEC, handles or enforces the FCPA. And the job of the commission is to regulate or oversee financial markets. If you're doing financial business or are involved in any type of financial service, the SEC will oversee your operations. And this is because the SEC is involved with the FCPA because the FCPA applies to companies or people who somehow touch the U.S. to do business. And one of the ways in which you can touch the U.S. to do business is by trading your stocks or your bonds or your securities in their markets. So this is why the SEC is involved. All right, I'm going to give you a little bit of background. I'm not going to give you the whole history because, first of all, I'm not going to do justice, or at least I'm not going to try to compete with the New York Times. If you want to look at the history, the historic background of the investigation, look up the New York Times article. It's very well written and it's fairly thorough. I'm just going to give you key aspects of the investigation or the allegations, and most of them involving Mexico because that's where the largest part of the scheme took place. Okay, so starting in 2003, several corrupt acts were reported internally through internal Walmart channels. That means company email. Okay, now a lawyer that used to work in Walmart and that was savvy to the improper acts reported to their superiors that several people in Walmart in Mexico, several executives, were paying bribes to government officials. Now, this led to an internal investigation, and that internal investigation yielded results that essentially stated that Walmart had paid around $24 million in bribes in Mexico to government officials. This investigation was pretty much ignored and covered up. Obviously, the actual facts are more nuanced. I'm just giving you the broad strokes. Okay, now later, after the original investigation, the New York Times published an investigative journalism report, an expose detailing the bribes and detailing the actual cover-up, which mostly constitutes all 3 crimes covered by the FCPA. Following the report, the scandal, executives tried to essentially mitigate and do damage control, but they did so using a very pragmatic and selfish approach. Their main goal was to avoid more problems for Walmart in the near future, and so they just kind of did damage control, and that was it. The reports were ignored and they were covered up. the investigations were ignored, and they were also covered up. And Walmart actually reached out to the DOJ and stated, well, we found some conduct, but it's not too severe, so really nothing to worry about. But there was, in fact, quite a lot to worry about. Now, the crimes that Walmart allegedly committed revolved around paying bribes to the government and essentially for permits, mostly permits for construction, other government services, operational permits, environmental permits, and things like that. Now, this is where it gets interesting. Again, the typology, the news, and the case are all rolled up into one. The typology claim in this case, we've talked about third-party intermediaries. Now, third-party intermediaries are, broad strokes, someone outside the company whom you pay to pay a bribe. So you don't pay it directly, you employ someone else to pay the bribe for you. Okay, in this case, these TPIs, or third-party intermediaries, were fixers, what we know in Mexico as gestores. Essentially fixers, people who take care of administrative processes for you, and they are not lawyers, but they are savvy to how the processes work, and they know how to grease the wheels of justice, so to speak, so they take care of this business. Okay, now allegedly, the way the bribes were paid was this. The government process was identified and by Walmart executives. They also identified the public official that was in charge of that process. They set the amount of the bribe, probably in negotiation or in consultation with the public official, and the bribe was paid, but not to the official. Walmart paid the bribe plus a 6% overhead to the TPI, the fixer. Most of the times this was these fixers were law firms, relatively small law firms. Now, the TPI, the lawyers, paid the bribe to the public official, so Walmart didn't pay directly. Now, internally, what the lawyers did was they took their commission, 6%, and they issued an invoice. They paid the bribe, obviously, and they issued an invoice to Walmart. Now, those invoices would bear on their face a 3-character code, a 3-digit code. Now, this 3-digit code was used in a somewhat sophisticated attempt to identify the reason for each bribe. So you would see an invoice, and the invoice would say for legal services rendered, IGF, or something like that. And these, I'm making up the letters, but these letters would tell the people inside of Walmart what they were buying with their bribes. Inside information, trafficking and influence, making an investigation go away, getting early permits, getting fast-track permits, and all of that very, very nice stuff. So again, a fairly sophisticated system to identify the bribes. And also this made it difficult. The use of the codes made it difficult for the authorities to actually prove that the bribes were paid. That doesn't mean that they don't know that they were paid. That doesn't mean that they could not have proved it in a court of law. That just means that it was harder for them. And of course, this never reached a courtroom, so there'll never be a chance for that. Okay, so following that, the entire thing blew up in the media. And this led to a wide investigation by the US authorities. So let's talk about the investigation, the negotiation process that ensued, and the resolution process that took place earlier this week. Okay, so administrative proceedings began in 2012. That means that the DOJ and the SEC began their investigations and their inquiries into Walmart. Walmart partially self-reported. Now, again, self-reporting is when you go to the authorities and you say, mea culpa. I did this, and I'm sorry, and please give me some credit for confessing. Now, we say that it was only partial self-reporting because the authorities already knew about the misconduct, and they're not going to take into account something you disclosed when they already know about it, because it's not spontaneous. It's merely considered a mitigating effort. This led to a DOJ investigation. This is a full-on legal forensic investigation to reconstruct the facts and figure out where, if anywhere, criminal responsibility has to be allocated. Walmart, throughout this process, we have to state that they cooperated heavily, so much so that to those in the know, Walmart has reported to the authorities that it spent over the entire 7-year period around $900 million just just in cooperation measures to mitigate the problems with the case. So that means legal fees, fees to enhance compliance programs, training, ethics codes, policies, things like that. So quite a bit of money. Okay. What happens during these investigations is that the authorities look into everything that they can find. They figure out the facts and they decide whether or not to bring a charge. They say, well, there very clearly was criminal activity here and we're going to take you to court, or at least we're going to threaten you to take you to court and punish you with a very, very big fine. Again, the details are unclear. Only the people at Walmart and their legal counsel are privy to the details. But what has come through the grapevine was that before the end of the Obama administration, Walmart was eager to settle this issue. They wanted to resolve this issue before President Trump took office. So they approached the administration, the Obama administration, different head in the Department of Justice, different head in the FCC, an entire different staff. And the administration offered Walmart either a non-prosecution agreement or a deferred prosecution agreement. For our purposes, a deal. And that deal, allegedly, the rumor is that it entailed an admission of guilt by Walmart to all three crimes: bribes, faulty compliance systems, and books and records violations. A fine of $1 billion. That's billion with a B. $1,000 million. A monitorship is essentially you pay someone to audit you internally and report to someone else, in this case the government. And cooperation, so turning in information, documents, data, people, anything that the government requires. And possible disbarment. Disbarment means that you are placed on a blacklist and you cannot do business with the government for a set period of time. Walmart rejected the offer. It wasn't surprising because the fine was so heavy, but I think pretty much everyone in the compliance industry expected a fine over $1 billion. To give you a frame of reference, Siemens settled their bribery case, this was in 2008, for $1.6 billion. Now, half of that went to German authorities and half of that went to the US authorities, but it's still a very large fine. And the allegations were at least less severe in appearance than those in the Walmart case. So we expected a fine at least as big as that. That didn't happen. Let's fast forward to the Trump administration. In 2017, the Trump administration, new heads of the SEC, new heads of the DOJ, made a new offer to Walmart, an offer for an MPA or a DPA, a deal. That deal presumably entailed the admission of guilt by Walmart to three crimes: bribery, books and records, and faulty compliance systems. Fine of $300 million, a monitorship, cooperation, and possible debarment. Again, Walmart rejected this deal. Now, why did they reject a deal that essentially amounted to a 70% discount? I'll tell you, I'll give you my opinion. I feel it has to do with disbarment. Now, let's talk about the deal, the two deals that Walmart signed this Thursday. The first one is a cease and desist order signed with the SEC. It's a deal. It's a type of deal that Walmart signed with the SEC. Now, this was signed between the SEC, the Securities and Exchange Commission, and Walmart Inc., because Walmart Inc. is the company that actually trades its stock in the US stock exchanges. This deal entails for Walmart the admission of two crimes, not three. Two crimes: the crime of having faulty compliance systems and the crime of misrepresenting their books and records, their accounting records, so as to prevent corruption. But it doesn't entail the admission to the crime of bribery. Now, let's see if let this sink in for a bit. Walmart admits to having rules and systems that can't really prevent bribes. And they also admit to falsifying their accounting records, and that falsification, that cooking of the books, leads to hiding of corrupt acts. But they don't admit to actually paying bribes. And the commission is surprisingly silent on the issue. You can read the entire deal we have, and the deal does not say anywhere that Walmart paid a bribe. which is very surprising considering the evidence. What else? Walmart has to pay a disgorgement of $144 million. Now, disgorgement is not the same as a fine. The end result might be similar, but disgorgement means that we confiscate the proceeds of the crime. I very highly doubt that Walmart only made $144 million from their corrupt practices. But hey, it also entails cooperation, fairly standard, and periodic reporting, fairly standard. They signed this, and the deal with the SEC also acknowledges the deal with the DOJ. Now, this is where it gets very, very interesting. Walmart signed a non-prosecution agreement with the DOJ, a deal with the DOJ, but this deal was signed between the Department of Justice and WMT Brasilia SARL. It's fancy words for Walmart Brazil. Now, not Walmart Inc. Again, this deal is criminal in nature because it's a criminal prosecution, and in this deal, Walmart admits to the commission of 2 crimes, but never the crime of bribery. Yes, my compliance systems are horrible. Yes, I falsified my records, but I never paid a bribe. So yeah, nobody's going to buy that. Also, a fine of $138 million, but no disgorgement. The fine, $138 million, very clearly violates the principles set forth in the OECD Convention to Combat Bribery. That convention, it's essentially an international treaty that says every country will punish foreign bribery, and when you punish foreign bribery, your penalties will be effective, proportionate, and dissuasive. Nothing about the $138 million paid by Walmart seems to us effective, proportionate, nor dissuasive. But hey, we're not the ones in charge. It also entails cooperation, fairly standard, periodic reports, of course, enhanced compliance programs. Yes, well, practices that Walmart had already been putting in place. So we do have to give them credit for doing that. A 2-year monitorship. So for the next 2 years, Walmart will have an external party review their books and records and their practices and report to the DOJ. And finally, does the deal entail disbarment? Does the deal preclude Walmart from doing business with the government of the US? No. First of all, even if it did, the deal was signed with Walmart Brazil. So that would preclude Walmart Brazil from doing business with the government of the US. But here, it doesn't even cover that. So Walmart is very much able to do business with the government. It paid a reduced fine. And this is all very suspicious to us because of the amounts, because of the penalties, because of the reduction in the penalties, and because this all comes in the context of a fairly obvious commercial conflict with China, and very delicate or hostile commercial negotiations between the US and Mexico. And coincidentally, Walmart does a lot of its business with China and with Mexico, and most of the bribery schemes that were hatched and most of the alleged criminal conduct was committed in China and in Mexico. To us, this seems, to say the least, highly irregular, to say the most suspicious. This doesn't come at a great time. Again, the heads of the DOJ and the SEC were appointed by Donald Trump. The heads of the divisions that handle FCPA violations in both government entities were appointed by Donald Trump. And this whole thing is quite irregular. But of course, we will have to see how it develops. Our main concern is that, as you know, FCPA cases have very seldom reached a courtroom. They are mostly settled out of court. And so in effect, the settlements are the actual case law or the actual soft law by which the FCPA is enforced. Now, this settlement changes the rules of the game. Does this mean that this is how this administration is going to enforce the FCPA? We don't really know. In any event, we will keep you posted to any new developments. I want to thank Laura Paola Villa, who contributed research to this article. And as usual, I'd like to leave you with this. Corruption should be reported. Please blow the whistle every chance you get, but please do so safely. If you're not sure whether or not what you're witnessing is corruption, or you're not sure that you're entirely safe, physically out of danger, don't do anything, refrain from acting, reach out to people who might help you. Feel free to reach out to us at info@streiner.mx, and we will be glad to help you, but above all, stay safe. Again, thank you for joining us. This was The Wife of Caesar, and have a happy Monday.